Agenda. Why don't we ever do consent on these meetings?
Well, as a point of order, I can say that 1 through 4, these are reviewed, these are just reports. We can take them as a group if you like.
I think that's a great idea. You want to make, is that a motion?
Unless the other commissioner decides otherwise, but I can make a motion that items 1 through 4, that we approve those.
It's been moved in second. All in favor, say aye.
Aye.
All right. Items 1 through 4 pass 3-0. Okay, we're on item number 5. Approve or deny the reinstatement of the primary residential exemption on the parcels listed on the attached spreadsheet. Do any of the employees have anything they want to point out in that? Anybody have anything they want to speak to on item number 5?
It looked pretty straightforward to me. I didn't see anything that jumped out.
All right.
Yeah, and I don't see anyone from the assessor's office here to speak to, so I guess it's just as it stands, so. Oh, Bert Garfield's back there.
He
No,
was-
Theron's? Oh, there's Theron back there.
Any issues with item number 5? We're good? All right, I'll entertain a motion.
I can second that.
It's been moved in second. All in favor, say aye.
Aye.
That passes 3-0. Item number 6, approve or deny petition to the Board of Equalization to hear the appeal of property valuation after the filing deadline.
Yeah, this is, the appellant's asking for the appeal to be accepted after the filing deadline on basis of a factual error. What they're stating would be considered a factual error. Usually this does require agreement by the assessor's office. I don't know if anyone from the assessor's office can hear to speak to that, but so we would typically defer to the county assessor.
Do you agree that there was a factual error?
Probably we can accept it and research it.
You're cool with that? Okay, I'll entertain a motion.
I can make a motion that we approve item number 6.
All right, it's been moved in second. All in favor, say aye.
Aye.
All right, that passes 3-0. Item number 7, approve or deny valuation for Board of Equalization to hear the appeal of property valuation after the filing deadline. On number 7.
Number 7, the appellant is asking for consideration for failure to notice. As I looked at the information provided and the history, it wouldn't qualify for failure to notice because the error is not lying with the county. It lies with the address recorded with the deed, which the company did correct. But I'm fine with the board giving them a mulligan here because this is a first-time offense, meaning that they recently purchased the property, and when the mistake was discovered, they immediately got the address updated. So they're managing their address. I think we should probably, reward good faith efforts. So we have no issues with this going forward.
Any disagreement from the assessor's office? All right, I'll entertain a motion.
Motion to approve 7.
I can second that approval.
All in favor, say aye.
Aye.
That is approved 3-0. Item number 8, approve or deny application for new properties tax exemption for Utah Valley Family Support Center.
There she is.
Oh, I missed that one.
Here-
Nope, go ahead.
Vicki Westergaard, tax admin. This is a new property that, I believe this is Utah Valley Family Support Center, doing business as Family Haven, a new property. This is their second location. We already approved the first one, and they did apply timely, and I believe Janelle is here to talk about it.
Good afternoon. It's good to see everyone again. This is a location that probably is familiar to you and as dear to your heart as it is to ours because of the funds from Utah County that were supportive of this initiative to start a second location of Family Haven. So we're excited to be able to offer services in that area and hope that this is just one piece of the puzzle to making that happen.
All right. I'm
Commissioner?
good with this one. Yeah.
We do had some questions on this.
Yeah.
Because where it asked about the non-use of parcels, it said it was not being used for all activities described in previous questions because of licensing requirements. So we were just wondering if that had changed any?
We're in the process. So we have 2 different licenses that we function with in our Orem location, a residential support license for our crisis respite nursery and our outpatient treatment license for our clinical program. And we are in the process with the state of securing those licenses. It's just a matter of their timeliness to get those back to us.
And it says that there's a part of the building that is being used. How much of it is being used now?
Well, it depends on the day or the services provided. Family Haven does a lot of work with community partners, and so we've had several events throughout the last several months to coordinate services with United Way of Utah County, with the community action projects for the Day of Caring that United Way has done. But on a day-to-day basis, there's probably, I would say, 3 offices that are used on an active.
So how much
Active involvement.
percentage of the building do you think that is?
Oh, that's.
Do you rent out any of it to for-profit, or is any of it used
No,
for anything?
100% of the building is used for our purposes.
Right, you're just not actively doing all of the things yet.
Right, exactly.
And when you have used it,
coming.
it's been in conjunction with other nonprofits? Have
Right.
you rented it for any for-profit
No.
activities?
No,
And we've given allowances when a institution was in the process of refurbishing. We've allowed
Right.
that in the past too.
Yeah, and it was denied until they got their license, to
That
have
one
the
in
people come
Payson,
in.
is that the one in Payson?
Heritage Behavioral, one of the places where children go in and stay, they had to get the license.
Yeah, they had to do that. But we've made some allowances for other organizations that while they were building, that we allowed the tax exempt status while they were refurbishing.
We
held it.
have not.
There was one, I thought, in Payson that we had about a year or so ago.
Do you remember, Adam?
It was a,
That would be, Commissioner, I'm sure, this is Bert Harvey with the Auditor's Office. I think you might be thinking of the Hewish Theater.
Yeah, the
Because they're under
theater.
construction.
Right.
Obviously, a different situation here.
right, different.
This isn't under construction, it's open and you have used it, but it's all been for nonprofit purposes. It's just not
Yeah.
fully utilized yet.
yeah. And I think out of our 4 programs, like I said, the nursery relies on a residential support license, the clinical services rely on an outpatient treatment license. Our parenting classes and our prevention education are the 2 that aren't associated with state licensure, and those are the programs that have been used at that facility.
So if I can add some clarification to the board, the law doesn't state what activities qualify a property for being in use. All it states is the property has to be in use, which is signified either being put into use or construction commences or a building permit is issued. Obviously, the building has been refurbished. They've put it into some use. They're just not having put it into full use yet. So, but it sounds like, based on the application, the information, while they're still waiting for licensing for their clinical use, they have put into use for their other services. And so, the question, of course, is if they're renting it out to other, in a for-profit capacity, if they're not, but if they're renting out to other nonprofits, we have allowed for that in the past, where even if they're renting it out in a for-profit way, if they're renting it to another nonprofit entity, another tax exempt, we've granted a tax exemption. I believe the one I can remember the most is the food and care, basically the food bank here in Utah County, either United Way or they were renting out part of the building from the other one. And so, anyways. But as long as the nonprofit organization has committed the property to exclusive use, and they can show that through their application and through their questions answered here in the board, then it can be, the law would allow for an exemption to be issued.
Motion to approve.
I can second.
It's been moved and second. All in favor, say aye.
Aye.
That passes 3-0.
Thank you.
All right, thank you. Number 9, approve or deny the application for new property tax exemptions for Braid's Place. Vicki?
Is anyone here for Braid's Place? I sent them a letter and email about the change.
Anybody online?
Is anybody online?
Sorry, I've got a hand up on Zoom.
Okay.
Becky Oakley, does that sound familiar? Braid's Place?
Yeah, that's her name.
Okay, I'll bring them in.
This is a new organization that deals with children that have long-term illnesses, and it helps them and their families go through this time of respite.
All right, Becky, do you want to give us maybe an overview of what you're using that property for and when you'll be using
Sure.
it?
Thank you so much for letting me appear electronically. I appreciate that. This is also a building that you guys have, unbeknownst, you have a lot of things that you're important for and near and dear to your hearts, but this is from the ARPA funding given to Braid's Place last Christmas time to create a building for children with serious illness and their families to be able to have some skilled nursing care, some end-of-life suites, some reprieve from caregiving, that sort of thing. So that's what this building is.
Great. Vicki, did you have any questions?
Yeah, well, it's for the future, if they're approved. I was trying to find out if they would need to give us a charity plan next year.
Oh, yeah. I don't know if you heard that, Becky, but they're saying for next year, if you're approved, we'll need a charity plan that shows,
Okay.
I think, doesn't that show
And
how
I'll
much?
send them a letter that
You'll send
tells them
okay,
what all
perfect.
it needs to say.
Yeah, any kind of medical care, like nursing home or hospital, they have to provide a charity care plan as part of their package. So.
Okay. So they'll send you a letter.
Okay, and that's great. We'll be an interesting combination between medical care and disability through Health and Human Services. So we'll work closely with them to get it right.
Okay.
I can motion to approve item number 9.
Second.
Move in second. All in favor, say aye.
Aye.
That passes 3-0. Number 10, approve or deny application for new property tax exemption for Jones Hughes Heritage Foundation.
This is an organization that I believe is in Spanish Fork, Mr. Hughes, your property, where they have log cabins and they are been donated some more buildings surrounding the area where they'll have more exhibits.
Yeah, give us a quick overview of what you utilize that property for.
It's been a property that we've used for people in the community, the junior high school kids to come and visit. We have 500 coming tomorrow, and we've had about 1,500 come last year. During the 24th of July, we have a quilt guild that puts up about 80 to 100 quilts. We have Mountain Man and a lady that does spinning, and so it's more of a heritage preservation that started with Elaine Jones's grandfather who built the home, and then we've used these properties around it, and we're extending the property value to 2 more homes that are on First South across from the city park, and so we'll have a very good situation for a doll museum, a quilt guild museum, and other venues where people can come and see it. We don't charge. It's just a community service related to the history of Spanish Fork and the log cabins that were built there in the
Being sold or
1850s. Yeah.
You don't have to convince. I've been there. I know what they're talking about. Tom, you've probably.
Right in the neighborhood,
Yeah.
isn't it?
Yep.
Well, we
Downtown.
will entertain a motion.
Motion to approve.
I can second.
All right, so motion and second. All in favor, say aye.
Aye.
Aye. That passes 3-0. Thank you so much.
Thank you. Thank you. Thank you. Vic.
Number 11, approve or deny the 2023 application for new property tax exemption for scenic view assets.
This one I'm gonna let Adam talk about because this is a new organization. It's a what's it called?
Disregarded entity.
A disregarded entity is what this one is. And so, did you want me to hand the code out to them that I made copies of?
I'll talk them through it, and then if they would like to see it, I can give it to them. Thanks, Commissioners. Adam Beck, Utah County Attorney's Office. So in order to qualify for one of these charitable religious educational exemptions, the applicant needs to be a nonprofit entity. Normally, an LLC we would look at, and it would not be considered a nonprofit. However, the code does carve out an exception or provide more wiggle room for a nonprofit entity. It says a nonprofit entity includes an entity if the entity is treated as a disregarded entity for federal income tax purposes and wholly owned by and controlled under the direction of a nonprofit entity, and for which none of the net earnings and profits of the entity, nor to the benefit of any person other than the nonprofit entity. So going through this application, what we thought is that the applicant would be one of these disregarded entities allowed under this code. However, we wanted to allow the applicant to come and speak to that. If they are in fact a disregarded entity as allowed under this section, we think it would be fine. If they cannot show that, then we would think that they probably would not be eligible for the exemption.
Is there someone here from Scenic View Assets? All right, we've got a couple people. Why don't you come forward? Oh, okay.
Bruce Olson.
All right. He'll promote Bruce.
Come on.
It's in that IRS paper.
There we go.
All right, Bruce, you're free to unmute yourself and address us. Bruce, you're still on mute if you're talking.
And until he gets going, maybe I'll just give you a little additional information
Oh,
here.
wait, hold on, now he's unmuting. Bruce, you
Can you
ready?
hear me now?
Yes, we can hear you now.
I apologize. Good afternoon. My name is Bruce Olson, and I appreciate being able to work with Adam on this. Scenic View Academy has received a property tax exemption for many years as it houses young people with neurodiversities and other concerns. What we have done is set up a disregarded entity called Scenic View Assets LLC and transferred the property that has been exempt over the years from Scenic View Academy. It is exempt under the Internal Revenue Code as a disregarded entity. The articles and the operating agreement of this organization provide that there can be no private inurement or private benefit to any private party. So I think it meets the requirements of the code section that Adam referred to.
Adam, do you have any concerns with that? Any questions?
I don't think I have any questions. I did speak with Bruce for quite a length of time about this, and so I don't think I had any questions.
They filed timely.
And they did file timely.
Right.
Bert, I don't know if you had any questions.
I'd just like to just like to chime in that both Adam and I talked about this and we went through the affected statute too as well. This is the first time for both of us dealing with a situation like this. From everything that we can research, it looks like this type of application of an LLC is allowed with under Utah state statute, and so as long as the property and the ownership meets the qualifications, which Scenic View has for a number of years, the fact they're putting it into putting a layer of protection with an additional LLC seems to be allowed under the law. So it's interesting to know that this is one of the few times. One of the only times in Utah state law that I've seen where this type of dual ownership or kind of protected ownership is allowed. For example, someone applying for abatement a property can't be owned by an LLC and that property still qualify for abatement even if the LLC would be a disregarded entity because the law is very clear about the ownership. So
Okay,
from an administrative standpoint, this looks pretty good.
that's good. I have no further questions. Do either commissioners?
I have none. I can make a motion to approve item number 11.
Second.
Moved in second. All in favor, say aye.
Aye.
That passes 3-0. Thank you, Bruce. Right, number
Thank you.
12, approve or deny the application for new property tax exemption for the Church of Jesus Christ of Latter-day Saints.
This is a new application for the DI and the Bishop Storehouse in Saratoga Springs.
Okay.
That was just transferred from suburban land reserves to the church's name.
Okay,
Hi, Kelly Taylor with the Church of Jesus Christ of Latter-day Saints.
Kelly.
We built this, oh, do you have a question? Sorry.
Sorry.
We built the DI and the storehouse, and it officially opened in September of 2022. And we just finally got the deed fixed, and now we're applying for exemption.
Right, and it's open and functioning.
Open and running and
Do we
functioning.
have any questions or concerns, Vicki?
Nope.
Motion to approve item 12.
I can second.
All right, it's been moved and seconded. All in favor, say aye.
Aye.
All right, that passes 3-0. Thank you. Okay, item number 13, approve or deny application for review by the Board of Equalization for the Farmland Assessment Act for Tim and Natalie Crandall.
Good afternoon, board members. I'm Katrina Cole from the Utah County Attorney's Office. I'm here to speak on behalf of the assessor's position for this appeal. So I'll give like a brief overview and then go over some of the facts. As you're aware, the assessor's office has a statutory and constitutional duty under Article 13, Section 2 of the Utah State Constitution to ensure that everyone is assessed and taxed at a uniform and equal rate, and therefore taxpayers applying for preferential tax treatment under things such as greenbelt or urban farming must be strictly eligible to qualify for the preferential rate. Otherwise, we're unfairly shifting tax burdens to other taxpayers across the county. As a brief overview of greenbelt, property can qualify for the greenbelt treatment under Utah Code 1592 Part 5 if it's 5 or more contiguous acres, is actively devoted to agricultural use, and has a reasonable expectation of profit, and meets other qualifications that aren't really an issue here. So in this case, Diane Garcia, the county's farmland assessment analyst, reviewed the application for greenbelt status from the taxpayer before you today. She denied that application because the property in question is not 5 contiguous acres. So there are 4 parcels of land. The 2 most southern parcels are contiguous to one another. And then just north of those parcels is an orchard that is managed, to my understanding, by the taxpayers, but owned by another party. And then to the north of that orchard is a road, and then the 3rd parcel. And the 3rd parcel also contains the residence. And then if you continue north, there's a road, a row of houses, and the 4th parcel. So while these parcels collectively may be 5 or more acres and meet the production requirements, none of the parcels individually meet the 5 contiguous acre requirement that is necessary for greenbelt. There is an exception to the 5 contiguous requirement that allows parcels to be non-contiguous. However, the non-contiguous parcel has to be in conjunction with other eligible acreage. So, and as I mentioned before, none of these parcels independently are eligible for greenbelt since none of them are 5 or more acres by themselves. And so this exception doesn't apply in this case. So as you can see with these photos, it's to the right, you have the first 2 parcels that I mentioned, then you have the 3rd parcel with the residence, and then you have the fourth parcel over to the side. And so these are not contiguous. They're not just separated by roads, which is potentially allowed under the statute. They're also separated by houses and by another orchard. And so they don't meet the requirements for greenbelt. So I'd also like to address 2 of the arguments the taxpayer made in their appeal. First, they argued that the property should not be subject to the rollback tax because the parcels qualify for urban farming, and they are planning to apply for urban farming. And in talking to Diane Garcia, it doesn't appear that, it does appear that they would qualify for urban farming, but we haven't yet received an application for the urban farming. And second, they mentioned that they received greenbelt status back in 2007, 2008 for the non-contiguous parcels, and removing them now would be arbitrary and capricious in their view, so they would like to continue having greenbelt. Unfortunately, just because you fly under the radar once doesn't mean you get to fly under the radar every time after that. If you speed 99 times and get caught in the 100th time, you don't get to get away without a ticket. It's the taxpayer's responsibility to make sure that they are compliant with the law and the requirements of greenbelt, just as it is for all of us to make sure that we're not speeding on I-15, regardless if there's a policeman watching. So for these reasons, this appeal should be denied. If you are wanting to, there might be a possibility to continue this hearing and wait for them to apply for urban farming. Then everything except for the residents, because that isn't allowed under urban farming, everything else could potentially go into urban farming and get the rollback that way. But as it stands right now, without that application, this appeal should be denied. If you have any questions,
And is this appeal to keep them on greenbelt, or is this for the rollback?
This,
Or, I mean, I guess the rollback would be,
Keep on Greenbelt. So the ultimate aim is,
Yeah, it's sort of the same thing. They get rolled back and assessed, they get rolled off of Greenbelt and assessed a rollback tax, and so they've appealed that decision, so they should still be on Greenbelt and they shouldn't have to pay the rollback tax.
the question I had is that contiguous means neighboring, adjacent, in contact, or touching, or very close. But it also means proximate, near, or nearby. So there's a little contradictory in definitions as when I looked it up, but
is that the definition under the code?
of contiguous.
yeah, but is that the definition in the law, or is that the definition?
Yeah, I'm
Webster?
curious.
I
mean, I
It
can-
seems to be,
Webster.
that's was,
Here, let
it's
me-
not Tom's dictionary, but I was trying to dig to see what do we have in the state law that defines contiguous. Because
oftentimes there's
it's so
a term
close.
like
We
that.
had something very similar to this for Spanish Fork a month or two ago, but we've denied it because the property that was separate was actually not in full use as defined. But we were considering it, that one at the time. Those two properties were fairly separated by, I think, 200 or so feet.
Just before we get too deep into this, my preference would be that we continue until they apply. Because, I mean, if you're looking at this map, assuming this is a recent map, this is obviously land that is, they're doing production on, and I think there is production, and I think they would qualify for urban. So my preference would be to continue this so that they get a chance to apply for urban farming, because under the new regulations that were passed this legislative session, then when they convert to urban farming, it deals with the rollback. So if we do this now, we're gonna have to, let's say we approved this. Well, let's just say we deny it. If we deny it according to state law, then we have a rollback that we're gonna have to deal with an abatement on. Plus then they're gonna apply for urban farming, but we will already have the abatement that we're gonna have to deal with. If we approve it, then there's an appeal to the State Tax Commission, who will likely deny it. I think the easiest thing for us and for them would be for us to continue this, for them to apply for urban farming, and when they get urban farming, it will handle the rollback.
Yeah, and I think that that's a reasonable approach. To my understanding, that would be an easier way for all of us.
Yeah, because even if we approved it, we have to deal with an appeal to the State Tax Commission.
Reading in the packet, it looks like that was offered to them, and I'd like to know why. Maybe are they here?
Yep.
Is it, okay.
Yep. Would you like us to approach?
Yeah, absolutely.
Sorry, is that?
Yep.
You see what I'm getting at?
Yep.
Like
And that's,
that
and
was given that opportunity.
yeah.
Maybe they don't want to.
I'm Catherine Carlisle. I'm representatives for the Crandalls. So to answer your question, it was our read that the application needed to be filed within the next year following the withdrawal. And so 2023, right, would be the year of withdrawal, if that were in fact to happen. And so they're prepared to file the application maybe even as soon as today, and fully intend to do that. And really the essence of our appeal is, and as set forth in the application that was filed, is to, fit within the urban farming framework.
Okay, so it was basically you were meeting a deadline.
Yes, yes.
Okay, so
That's
do you have any issue with us continuing this and giving you time to apply for the urban farming?
If you want an application to come in first before the hearing, absolutely. I think that
I think that makes it makes it a lot cleaner for
Yeah,
us.
that's
and-
fine. Yep. That's the intent, yep, is to file it.
Okay,
That's how I understood it in the packet, that it would qualify.
right, but you had to
Farming.
apply for this now to meet the deadline. Okay. Yeah, I think that would be easier for everybody. I think it's less work for all of you to do it that way. Let's wait let's make the urban farming application. How long should we continue it for? Anyway,
It may be partially a function of what the applicant needs, but if they're ready today to file it, I don't know that it needs to be continued for that long. And maybe it's a question for the assessor's office of how long they need to process that
when's our next
application.
BOE meeting? 3 weeks? Can we get that done in 3 weeks? If you guys can apply and cannot get through your process, your workflow in 3 weeks? So we just continue that for 3 weeks, and then that gives you time? That works for everyone?
That absolutely works for us, yes.
Okay, I'll entertain a motion to continue for 3 weeks.
So moved.
So moved.
Okay, thank you very much.
Second.
I'm going to have a motion and a second. All in favor, say aye.
Aye.
That passes 3-0, so that's continued for 3 weeks. Okay.
Motion to adjourn?
Second?
Been moved and seconded that we adjourn. All in favor, say aye.
Aye.
Here.
passes. We are now adjourned. 30 minutes, guys.
Goodbye.
Good job.
Oh, I know. Oh, I know. I do. I've seen some of, I've heard.
Hey, Ben, we really need